But all right, Miss Fortuna Gill, where are we proceeding today?
We're ready on Miss Doms, Your Honor.
All right, Stephanie Doms. Lee, how are you?
Very well, Your Honor. How about yourself?
Pretty good. All right, so we're on the record in 2503582. That is People of the State of Michigan versus Stephanie Doms. Today's the 12th. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Stephanie Marie Doms.
And ma'am, you are Stephanie Marie Doms, is that correct?
Yes, Your Honor.
Okay, and you're joining us by Zoom today, is that correct?
Your Honor.
And you can hear me all right, Ms. Doms?
Yes, Your Honor.
Thank you. This time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I will defer to Mr. Lee.
Mr. Lee.
Thank you, Your Honor. Ms. Doms has been in contact with a rehabilitation facility called 1016 Recovery Network in Midland. She has made arrangements to check in there after this hearing today and to begin a 30 to 45 day program. I believe she said she requested the 45-day program. So what we would like to do, Your Honor, is run this probable cause conference and then adjourn the preliminary exam until after her treatment, if the court grants.
All right. And is there any objection to the adjournment with continued pretrial conditions, Ms. Fortuna Gill?
No objection, Your Honor.
Now, I can't tell at arraignment. It looks like because there's no the scram. There was a scram tether issued. Bond conditions may not be within 2,000 feet. May not contact the complaining victim. May not use social media to contact. May not have third-party contact with Michael Doms. I can't read these names. Javier Doms, Houston Allen Michael Doms Haley. May not be within 2,000 feet of 506 South Magnolia and must report to 30th Circuit pretrial services within 24 hours of release. That is all those are all the conditions. I don't know if this is, but those are the conditions of the pretrial release. Is that a fair statement, Ms. Fortuna Gill?
Yes, Your Honor.
To the best of your knowledge. And yourself and Mr. Lee.
Yes, Your Honor.
All right. So I'm going to indicate, so Ms. Doms is going to waive her right to a prelim within the 21-day period?
Yes, Your Honor.
All right. So Ms. Doms, do you understand you have a right to a preliminary examination? A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. That right is available to you within 21 days of your date of arraignment. It is my understanding it would be your wish today to waive your right to a preliminary examination within the 21-day period so that you could go off to a rehabilitation clinic in Midland, Michigan. It's my understanding you wouldn't be waiving your right to a prelim in general, just to have a prelim within the 21-day period. Is it your wish today to waive your right to a prelim within the 21-day period?
Yes, Your Honor.
And Ms. Doms, for the record, how are you getting to the rehabilitative facility?
My oldest daughter is supporting me there. It is inpatient. I've also spoke to the people with the tether, with the scramble. They are also aware of it. They have also given me the consent for that for as well.
So they know the scram tether that you'll be going to the facility. Is that correct?
Yes, yes, Your Honor.
And it's your wish today. Forgive me if I'm saying this again. It is your wish today to waive your right to a prelim within 21 days. Is that correct?
Yes, Your Honor.
Ms. Fortuna Gill, are the people also waiving their right to a prelim within 21 days?
Yes, Your Honor.
I find the waiver of the preliminary examination waiver of the 21-day rule to be knowing, voluntarily, and accurately made. So the defendant has waived their 21-day rule. I do have a 5,000 cash surety bond, so that it's a 5,000 cash surety bond on the file, and then we want to make sure to reschedule. I would think after the rehabilitative stay.
Yes, sir.
So that would be what, 40 days?
45 days. I think you
45
said,
days
Mr.
is what you reported.
So preliminary examination to be scheduled after 45 days? That would be, I would say, 6 weeks.
Approximately.
Thursday, Friday, 6 weeks, maybe 7 weeks to be careful.
Yes, sir.
I thought the first week.
That's probably the safest.
Yeah.
Yeah,
I'm waiting for my approval for JIS.
okay.
Well, I had a date, but now I gotta find a new one. How about February 5th at 8:30?
February 5th at 8:30. Okay, we'll set it for February 5th at 8:30 for the preliminary examination. That is for the preliminary examination. So set it for February 5th at 8:30. So Ms. Fortuna Gill, you'll have your witnesses scheduled for that day for the preliminary examination. Anything else, if that becomes a problem with the rehabilitation center, just let us know and we can move that. We can move the date. But just let us know. Anything, so we've reset this preliminary examination for February 5th at 8:30. Ms. Doms, anything else for the record in 2503-582, Ms. Fortuna Gill?
Not for the people.
Mr. Lee?
No, thank you. Your
All
Honor.
right. All right, Ms. Doms, we'll see you on February 5th at 8:30. Thank you for your appearance today.
I appreciate you all.
Thank you.
We are ready on Young.
That is Devonta Young.
Devontae.
Devontae. Mr. Milks, how are you?
Your Honor, I'm fantastic. How are you?
Pretty good.
Good.
And he's joining us via
Post 2, visit 4.
post 2 visit 4. Thank you.
You think he probably homeschooled watch that one through the window?
Can you turn it up a little
All right.
bit?
Mr. Fisher, we can hear everything you're saying, so you probably want to mute yourself.
Okay.
All right, thank you. All right, so we're on the record in docket
How do you-
2502449. That is people of the state of Michigan versus Devontae Young. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Milks.
Thank you, Your Honor. Stephen Milks on behalf of Mr. Young. Mr. Young with us via polyconference line.
And sir, you are Devontae Young, is that correct? Can you hear me, Mr. Young?
No.
I can hear you. You want to? Can you hear me?
I can't hear you.
You probably want to get closer to the mic. I can hear you. But you should scoot up closer to the mic because you're kind of breaking up. No, I don't think he can hear.
Can't hear anything.
All right. Let's email the post because there's somewhat of a problem.
Yes, Your Honor. He's technically here. I've had the opportunity to speak with him already, Your Honor.
Right.
So if we plan on leaving this on.
Can't hear
Prosecutor's
anything.
attention.
All right. All right. So he's technically here. I can hear him. We'll waive his appearance for these purposes. Mr. Milks, you're indicating that is Devontae Young. Is that correct?
That is correct, Your Honor. That is Devontae Young. I've had the opportunity to speak with him.
All right. So let's go ahead and leave. So I'm going to call it on the record. And then Mr. Milks, you can go down and talk to him, tell him we left it on, which he expects now.
Yes.
Okay. All right. So we're on the record in 2502449. That is people of the state of Michigan versus Devontae Young. And Devontae Young is here. He is present. He's incarcerated and he just can't hear us. So for the record, Mr. Milks is going to explain to him what we did here today, which is just to leave this on. We've had the PCC and it's just going to be left on. Is that a fair statement, Ms. Fortuna Gill?
Yes, Your Honor.
Mr. Milks?
It is, Your Honor. Thank you.
All right. So we'll leave on for the previously scheduled preliminary examination for December 19th at 8:30. And Mr. Milks, you'll explain to Mr. Young that this is being left on per your request.
Yes, Your Honor.
And per the prosecutor's request.
Yes, thank you, sir.
All right. Anything else for the record in 2502-449, Ms. Fortuna Gill?
Not for the people.
Mr. Milks?
No, thank you, sir.
All right, Mr. Young, well, he can't hear me, so Mr. Young, Mr. Milks will be down to see you. You should be all set, sir. You can give him another thumbs up.
We're ready on Earl.
Did you want Miss, oh, I guess because the polycom didn't work. All right, so let's go on Earl, Treyana Earl for sentencing.
Yes, Your Honor.
Your Honor, but we need an adjournment, so.
Oops.
All right. So we're on the record well, we'll put it on the record. We're on the record in docket 25-019-01921. That is People of the State of Michigan versus Treyana Earl. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is not present.
This is the time set for a sentencing in the matter. I'll have what I have from the pre-sentence report that was prepared on December 9th, 2025. That the defendant has warrants out of 67th District Court and a failed to appear for sentencing out of St. Clair County, Alabama, and there's a full extradition. Full extraditions available in transit from Dakota County, Minnesota. Full extraditions available, and from Ohio, there's a larceny warrant from Toledo, Ohio, outstanding.
Your Honor, is that the original PSI or was there an updated one?
I have it prepared as of December 9th, 2025.
Okay, yeah, I don't have that one.
All right, so let's make sure and give you a copy of this. I didn't know, there was a PSI. She missed her PSI on October 3rd. Then she completed her paperwork, but I just got a memo. And then I did get a completed PSI on December 9th, but I don't know if I didn't know if council had that copy.
No, I was not given a copy of any new PSI. I know that she was in Medina County, Ohio until December 7th. At that point, she was transferred. I'm not exactly sure where, but the Medina County court records show that there was an extradition case. And I believe that she was sent for the warrant in Alabama.
That all seems to make sense based on my reading. Miss Earl's not here. She might, but we've got to figure out where to rid her out of, and we have to then figure out where to extradite her out of also, because she's probably out of state.
I'm also in contact with family, so the hope is that maybe when she gets to Alabama, there will be a pretrial release, and she'll return to Michigan so that she can appear for the next sentencing date.
Yeah, and I don't have the nature of why the extradition's going on. I just have Alabama, and Minnesota.
Yeah.
So there's a lot of chiefs in this equation. So Ms. Fortuna, so you're requesting an adjournment till we know where to rid her out of, which seems to be a fair request.
Rid her out or have her appear.
Or have her appear. Ms. Fortuna Gill, do you have the updated pre-sentence report?
I do not, Your Honor. The most recent PSI that I have is from October.
All right, yeah, that would be the one-page memo.
Yes.
Okay.
That she in.
All right, so I'll make sure before we leave today, you get a copy of the December 9th pre-sentence report. And so we'll adjourn the sentencing. Ms. Earl is based on the public defender's representations. And it would make sense that she's been extradited out of state. She may be here for pretrial services from out of state. But it seems to confirm what we already know. So we'll adjourn the sentencing. What's our time frame here? What are we looking at?
Your Honor, I would say that if you try to, any time in the new year, January, or February,
All right.
I think would be a good stopgap.
Let's do this. Let's adjourn the sentencing to February. I know I'll be here. So February, and we'll set it for Thursday, Friday, and or PCC sentencing date for in Friday.
I guess probably be February 6th.
Okay, February 6th. 6th at 9. And then in the meantime, we'll figure out where to rid her out of. I think it's Alabama, but we don't know yet.
If we need to, yes, I will keep the
Okay.
court updated.
All right. Anything else for the record in docket 250191, Ms. Fortuna Gill,
Not for the people.
Ms. Donnelly?
No offense.
All right, I will make sure we'll make a copy of the pre-sentence report. At least you have it for your record, so you can go forward. All right, that's all for the record, and my court officer will make you a copy. I think it's 2 pages.
Do you want copies or do you want me to just
Email.
scan
If-
it?
Yeah, just email it to them. Yeah.
And then we need Bentley brought up next, right?
Sure.
Yep. You can do that one then. We are ready on Wild Man.
Okay. That's Ms. Schroeder.
Yes.
All right, so we're on the record in docket 25-00156. That is People of the State of Michigan versus Darcy Wildman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Wildman, who is present, stands to my right.
And sir, you are Darcy Jacob Wildman, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I will defer to Ms. Schroeder.
Ms. Schroeder.
Thank you, Your Honor. At this time, we'd be asking the matter be left set for next week for preliminary exam. Mr. Wildman and I have had an offer extended from the prosecutor's office, and I would like I would like that time to be able to also talk about that with him, as well as his various support that he has with them. Thank you.
All right. So we've set for preliminary examination. Do we have to set it for date next week, or?
Oh, that's
don't-
right. We only set it for PCC.
I think we only set it for PCC.
You are correct, Your Honor. My apologies.
So, so we'll leave on
Actually,
for
wait.
preliminary examination. I'm not certain, since I think
I see it. I have December 19th.
I also have December 19th at 9:30 a.m.
perfect. But set for preliminary examination. You have better notes than I have on. Yes, we set it for prelim December 19th at 8:30.
I have 9:30 on mine. Is
Yeah,
it 9:30?
It's 9:30.
Okay.
The bottom of the page, 9:30.
And if we could also get a new copy of that notice for Mr. Wildman. so we
Yes.
can,
So we'll set it for preliminary examination. It'll be left on for December 19th at 9:30, and we'll provide a copy to Mr. Wildman for his appearance.
Thank you.
Anything else for the record in docket 25-00156, Ms. Fortuna Gill?
Not for the people.
Ms. Schroeder.
Now for the defense, thank you.
All right, Mr. Wildman, you get a copy of the notice for December 19th at 9:30. We'll see you next week. All right, sir? Thank you.
We are ready on Gary.
Maurice Gary.
Well, we got this here.
All right, so we're on the record in docket 25-03589. That is people of the state of Michigan versus Maurice Gary. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Maurice Gary.
And is Maurice Gary joining us via Zoom?
Yes, sir.
Okay. And sir, you are Maurice Gary? Is that the same post?
I don't believe he's incarcerated.
He's not incarcerated. No.
I don't see him on Zoom.
I don't see him on Zoom
Oh,
right
no.
now.
No.
I know he was joining about an hour ago, so I tried to contact him.
All right, all right. We'll place that file aside and call him when he gets here.
You want to go on Odrin? Okay. We can go on Odrin.
Odrin. Donald Odrin. Is that, and is he joining us by Zoom?
That would be on Polycom.
That's Polycom. Is
Yeah, I'm
that
here.
Post 2?
Post 1.
All right. All right, so we're on the record in docket 25-03596. That is people of the state of Michigan versus Donald Odrin. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Donald Albert Odrin Jr.
And sir, you are Donald Odrin, is that correct?
Yes, Your Honor.
Let's see, where's that coming
It
from?
might be the one that's with the
I'm on
black.
video, actually. It says I'm not on video.
Tell them to move, sometimes it's a
Yeah.
motion.
No,
What?
I think it's something with the camera. It's just gray.
Are you, okay,
So sometimes, you know what I'm talking
The
about?
motion says,
Yeah.
yeah.
is that post 1?
I think it's post 1 visit 3. I think.
Okay, so sir, you are Donald Odrin in post 1 visit 3. You are Donald
Yes.
Odrin, is that correct?
Yes,
All
sir.
right. If you move a little bit, that might activate the camera. If not, I think you're in the dark.
All right, 1 second.
All right, but, and you can hear me all right, Mr. Odrin, is that correct?
It
Yes.
doesn't look like it's on.
All right, thank you. This is time is set for a probable cause conference. Mr. Odrin's identified himself as the person who is in the Ingham County Jail. Ms. Fortuna Gill, how are we proceeding today?
Your Honor, the people would request that we leave this set for preliminary examination.
Okay, and Mr. Lee, is that your understanding? How are we proceeding?
Yes, sir.
Okay, so we've had the PCC and we're gonna leave on for preliminary examination. This will be left on for the previously scheduled December 19th at 8:30. So Mr. Odrin, your preliminary examination is left on for next week at 8:30, all right, sir?
Okay.
Anything else for the record in docket 25-03596, Ms. Fortuna Gill?
Not for the people.
Mr. Lee,
No, nothing further. Thank you.
you're all set, Mr. Odrin. Thank you for your appearance today.
See you, Spooky.
I gotta choose.
Sure.
So Mr. Lee, you're waiting on Mr.
I'm going to call Mr.
Gary.
Right now,
All right.
and I believe that's Zavala Miranda. That's in on Polycom. If I could talk with her briefly there.
All right. So is that's
Post 1 visit 4.
okay. So Ms. Zavala Miranda, we're going to place you in a breakout room with your public defender. All right, ma'am?
Thank you.
You're welcome.
I believe we're ready on Mr. Adams. I think that's what Mr. Neal is here for.
All right.
Is that,
That's correct.
is that what you said? Okay.
All right. Adams. And he is present via Zoom. Polycom. Polycom Zoom, one of those things.
Which one?
All right, so we're on the record in docket 25-03406. That is People of the State of Michigan versus Dante Adams. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Neal.
Good morning, Your Honor. Rico Neal, appearing on behalf of Mr. Adams. I am covering for the attorney of record, Mr. Robert Easterly.
All right. All right, and sir, you are Dante Adams, is that correct?
Yes,
And you can hear me all right, Mr. Adams?
yes, I can. A little echo, but I can.
Thank you, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding? Mr. Neal did indicate that he's covering for Mr. Easterly.
Yes, Your Honor. At this time, we're leaving this set for preliminary examination.
Is that a fair statement, Mr. Neal?
That's correct, Judge.
All right. So we'll leave on for preliminary examination. It was previously scheduled for December 19th at 9 o'clock.
We don't have an appearance in this file.
All right. Mr. Neal, make sure Mr. Easterly knows we have not received a full appearance on his behalf. That could be our system, just so Mr. Easterly knows.
Will do, Judge. Thank you.
All right, thank you. Anything else for the record in 25-03406, Ms. Fortuna Gill?
Not for the people.
Mr. Neal.
Nothing further, Judge.
All right, Mr. Adams, we'll see you next week at 9 o'clock. You'll be here next week at this time at 9 o'clock. Thank you for your appearance today.
Thank you.
We are ready on Culberson.
All right. Let's. Mr. Lee. We'll put Mr. Lee in. All right, so we're on the record in docket 25-03647. That is People of the State of Michigan versus Takesha Culberson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Ms. Culberson.
And ma'am, you are Takesha Culberson, is that correct?
Yes, Your Honor.
Thank you. And you can hear me all right, Ms. Culberson?
Yes, I can.
Thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding today?
Your Honor, at this time, we would ask that this be left on for preliminary examination.
And is that a fair statement, Ms. Robinson?
It is.
All right. We'll leave on for preliminary examination for December 19th at 10 o'clock. So it'll be December 19th at 10 o'clock. Anything else for the record in 25-03647, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson,
If I could be heard on bond, Judge.
you may.
We would be requesting Ms. Culberson to receive a personal recognizance bond. She does currently have a residence where she can stay at. She is staying at the Salvation Army shelter and doing the program there. She's also in the program at Michigan Works and is actively pursuing their job program there as well. I don't think that she would be a danger to the community. We'd be requesting a personal recognizance bond.
Okay, so she's staying at a shelter?
She's staying at the Salvation Army shelter. It's, I guess, different from like a normal shelter.
All right. Ms. Fortuna Gill, any response to the motion to reduce bond?
Yes, Your Honor, the people would object to any reduction or change in bond at this point. I have a note here that this defendant has a particularly violent criminal history. I'm currently trying to pull up said criminal history so I can tell you, but it's buffering, of course. Additionally,
The accusation is that she's previously convicted of felonious assault on January 29, 2013, felonious assault on December 10th, 2021. That's in Saginaw County, and the last one was in Ingham County, and then an R&O resisting obstructing out of December 2021 out of this county. That's what I have as the accusation.
Yes, Your Honor, and one of those, I believe one of those felonious assault files is currently open with my office.
Okay. And bond is set at $700, 10%. Is that was the bond set by the magistrate?
That's my understanding, Your Honor.
Any response to the people's response concerning the modification of bond?
Don't think that she has an open case, Judge. I know that she had previously had one, but.
Your Honor, it is, I do need to correct myself. My system sometimes says things are open after they were closed. I went into this file and checked. She does not currently have an open felonious assault file. That one is closed. Yeah,
well,
so Ms. Robinson is correct.
This is it's a 2-year, what we used to call high court misdemeanor. It's a felony, 2-year felony for R&O on counts 1 and counts 2. Bond has been set at 710%, so that's $70, a 10% bond. With the previous 2 felonious assaults, I'm going to deny the motion to reduce bond.
Thank you, Judge.
Thank you, Ms. Robinson. All right, Ms. Culberson, we'll see you on next week at 10 o'clock. Thank you for your appearance today.
You know who, if Mitchell has,
I believe it's
any representation?
Attorney Carla Morable on Zoom, but we
Oh.
don't have an appearance filed on that either.
Okay, well then we're ready for that if she's on Zoom.
This is Attorney Marable. I did file an appearance. I don't know if this went through. I was retained yesterday at 8 o'clock, and my office filed an appearance this morning.
All right, and so and you are representing
Anthony Mitchell. He
Anthony
is
Mitchell? All right.
Yes.
All right.
And with me just being retained yesterday at 8 o'clock, I don't have discovery, so I will be asking for adjournment. I will only need a week adjournment.
All right. Mitchell. It's Anthony Mitchell. All right, Ms. Fortuna Gill, are we ready to proceed on Anthony Mitchell?
Yes, Your Honor.
All right. All right, so we're on the record in docket 2503045. That is people of the state of Michigan versus, I'm sorry, 2503646. 2503646. That's people of the state of Michigan versus Anthony Mitchell. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Marable.
Thank you, Your Honor. Good morning to this honorable court. Carla Marable, P number 62755, on behalf of Mr. Mitchell. Mr. Mitchell, please state your full name for the record.
Anthony William Mitchell.
All right, thank you, Mr. Mitchell. And Mr. Mitchell, you can hear me all right?
Yes, Your Honor.
All right, this is the time set for a probable cause conference. It's been indicated to the court that Ms. Marable has just filed an appearance, just been retained a day ago, and is requesting an adjournment of the matter. Ms. Fortuna Gill, what is the response to the request for adjournment?
The people have no objection, Your Honor.
All right. Ms. Marable, we can leave it on for preliminary examination or just set that preliminary examination to be another probable cause conference. It's a 1-week adjournment, but that would mean that he's not getting his prelim within the time period. Does Mr. Mitchell intend to waive his prelim within 21 days?
Yes. So, Your Honor, I would need for us to adjourn it and set it for probable cause so I can get the discovery, sit down with him and go over it. And Mr. Mitchell understands that he's not waiving his preliminary exam. He's not waiving. He's only waiving the time limit because, Mr. Mitchell, you have 21 days of statutory to have your preliminary exam, but I haven't got discovery, so we would have to move it. You do understand that, Mr. Mitchell, correct?
Yes, ma'am.
Okay, because we're
All
not
right,
waiving
so-
the preliminary exam.
All right, so Ms. Marable, may I inquire Mr. Mitchell of his waiver of the 21-day rule?
Yes, Your Honor.
All right, Mr. Mitchell, you understand as attorney Carla Marable has indicated, you have the right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Carla Marable. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a prelim within the 21-day period. As Ms. Marable indicated, you are not waiving your right to a prelim in general, just within that 21-day period, so that Ms. Marable can get full discovery from the prosecutor's office, any police reports to zealously advocate for your defense. Is it your wish today, Mr. Mitchell, to waive your right to a prelim within 21 days?
Yes, Your Honor.
Do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And then, I'll look to see, when should we reschedule for PCC?
Can we do it next Friday so that, because Mr. Mitchell, I don't want to hold him up. I know that the prosecutor will send me the electronically, will send me the discovery either today or tomorrow. So can we do next Friday?
I think December 19th, that's the same date set for prelim. We can just change that to PCC date.
Okay, thank you.
All right, so we'll change the December 19th date at 10 a.m. to PCC date.
And I need to address the issue. Okay.
All right, and then so we've changed that preliminary examination date to PCC date. Is that a fair statement, Ms. Fortuna Gill? And is there anything else?
That is a fair statement, Your Honor. There is nothing further.
All right. And Ms. Marable, you indicated you wanted to look at bond?
Yes. So, Your Honor, in this particular case, it deals with a neighbor and they live across the street from each other. But Mr. Mitchell, that's his home, and his wife and his children live there. And there's a issue with he has a young daughter who gets off the bus, but they, and somebody has to pick her up from the bus stop and walk her home because of her age. She's not really able to walk home by herself. We're asking that he be allowed to move back into the house, which is 50 to 100 feet away from the alleged victim in this case, because that's his home that he has a lease on. He has been living there for 3 years. His wife and children are there, but his wife needs him there for childcare.
Yeah. The accusation is 6 counts, including discharge of fire at a dwelling. I don't want to get into the facts, but I'm not going to modify the bond concerning no contact orders, and that's a 2,000 feet no contact order. And you'd be requesting contact. That'd knock down that no contact order to 50 feet. That's not going to happen here.
Well, it would be more than 50 feet. They're across the street from each other. So I think it would be more. I don't think it's 1,000, but I think it would be something like 500-600 feet.
All right. Well, I can revisit this next week at the PCC, but at this time, I'm denying the modification of bond.
Okay. Thank you, Yana. We'll see you next week.
All right.
Bye-bye.
We'll see everybody at 10 a.m. for PCC next week. Thank you for your appearance today.
Thank you.
How does it 6 come? Oh, because
You can go on Jackson, Your Honor.
On Dyron Jackson.
I didn't call you last today.
I'm sorry.
I didn't call you last today.
No, you
Remember that.
All right, Mr. Jackson. And then, Mr. Lee, did you have the opportunity to speak with Miss I think it is, it's, yeah,
Yes, Your Honor, I did.
Miss Zavala Miranda, yes. So we can
Yes.
bring her back?
Yes,
All right.
sir.
All right. All right, so we're on the record. Let's go on the sentencing, and then we'll go on your case, Mr. Lee. So we're on the record in docket 25-03045. That is people of the state of Michigan versus, and you'll correct my pronunciation, Dyron Jackson. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Good morning, Your Honor. Thank you. Stephen A. Freeman, public defender on behalf of Mr. Jackson, who accompanies me at council table.
And sir, you are Dyron Jackson?
Dyran Jackson. Sir.
Dyran Jackson, thank you.
No problem, man.
This is the time set for a sentencing in the matter. And Miss Fortuna Gill, is there any other restitution that's been indicated here other than the pre-sentence report?
No, Your Honor.
All right, Mr. Freeman, have you had the opportunity to go through the pre-sentence report with your client?
Thank you, Your Honor. Yes, I did.
Any additions, deletions, or corrections?
No, we find it to be factually accurate.
Allocution, Mr. Freeman.
Thank you again, Your Honor. Ultimately, I'm going to move the court to adopt the recommendation for reasons slightly different than the reasons indicated in the report. I noticed that the author of our report was concerned that apparently his impression of Mr. Jackson was that he was not, I guess, taking the matter seriously, or he wasn't remorseful. And I would only indicate to the court that as a matter of law, my client is allowed to maintain his position. Sometimes defendants accept plea agreements just for reasons other than their agreement with the complaining witness. Sometimes it is simply to put together an agreement to disposition the case. In any event, he is otherwise eligible for a probationary period. He is gainfully employed, and his remembrance of what did or did not occur on the date in question is not to be taken in a negative. He simply has a different perspective of what occurred. And so with that in mind, I lastly offer for the court's consideration that the GPS tether on Mr. Jackson, I think, has served its purpose. I'm not aware, unless the court is aware, of any violations of that. I don't think he's had any contact with her. He indicates to me off the record candidly that he is not only able but willing to stay a good distance from her. He has no wish to continue that relationship. And so if the court saw fit, I would respectfully ask the court to incorporate a removal of the tether as a part of its sentencing today, if that was pleased to.
Thank you. Ms. Fortuna Gill, anything you'd like to say to the court on this case, on this file?
Your Honor, the people would just request that the court follow the recommendation.
All right, thank you. Mr. Jackson, do you have anything to say to the court before the court passes sentence?
I'm deeply remorseful for my actions that day. I don't have any intentions to harm Miss Jackson or go near her ever again in life. Honestly, I just want to take care of my daughter and keep going to work. I will be very appreciative if I can get the tether off. It's been almost 3 months. It's very hurtful, very hard to go to work with it, and definitely right now with this boot on to walk with it. So if I can get that removed, I promise to uphold whatever sentences you grant me today, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, so the court, this is for a guilty plea that occurred on October 17th, 2025 for domestic violence aggravated. It is the sentence of the court. that the defendant will spend 365 days in jail beginning today, credits given for 3 days, and then I'll suspend 365 days. So there's no upfront jail upon successful completion of probation. But it does leave the year, okay? It leaves the years hanging over your head.
I understand.
So this is a statute case. Fines and costs on the statute are $200 fines, $200 costs, crime victims' rights fee of $75, state fee of $50 for a grand total. There's no restitution in the matter. And then I will file the recommendation and have you placed on probation for 10 months at $30 a month. That is $300. So that's $400 plus $125 plus $300 is $825. So probation is placed for 10 months. Probation is just a different way of sentencing. You know that. I mean, so I could sentence you today. Those questions are asked because Mr. Neves just is you're gonna have to work with him for 10 months. And he wants to make sure that this is a person who he can work with. Some of those questions are, I think the majority of those questions are asked to see if you're a person who he can work with. Whether they're dealing with faults or not is one thing. He's got to work with you for 10 months. And so that's the person who would be in charge of probation violation or bringing it to my attention. Your indication is that's not going to be an issue. And I'm taking you at your word. You can work with Mr. Neves. And that probation will be for 10 months. So I'm going to follow the recommendation. Zoom reporting is appropriate. I'll place on here, Zoom reporting is appropriate. No assault, so I don't have to, no contact with the victim in this matter. I am going to remove the tether, okay? So we have no contact with the victim, and the victim being Jessica Jackson. And that will be 2,000 feet of her place of business, work, school, or person. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, controlled substance without a prescription. Submit to random PBTs. Enter your analysis as part of the request. And no bars or nightclubs is probably a good idea. Okay.
I don't like them anyway.
Okay. So people usually come in front of me because they drop dirty. So if that's not an issue here, this is your time to shine on that. Okay. I am going to remove the tether that's associated with this case. And you can go back, the private agency is right next to the jail. So you can go back to the jail and get this removed, okay? And we're gonna send them an email to that effect. Well, so that they should know you're coming, all right, sir?
Appreciate it.
All right, that'll be removed as a part of the order, but you still have no contact with Miss Jackson, you know that. Obtain and maintain employment. Not purchase or possess firearms, ammunitions, or weapons of any kind. That's all. That's my understanding of the recommendation.
There's fines and costs payable over probation, please.
Yeah, fines and costs are payable over probation. And I'll write that in.
Thank you, Your Honor.
So, Mr. Jackson, you're not a kid, and I'm not going to treat you like a kid, okay? If you're able to abstain from alcohol or marijuana or controlled substance, so and you're dropping clean, this is a pretty good report, okay? Because that's all you really have to do. other than not purchase or possess firearms and stay away from Miss Jackson for 10 months. That's all you have to do. I'm not worried about Mr. Jackson now because I got 365 days kind of over your head. Okay. I'm worried about Mr. Jackson 2 or 3 years from now when you got to make good decisions, and they can involve hurting somebody you allegedly care about. All right, sir. So that's what we're working on. So any resources that we can provide in district court, we're not always the most helpful, but we can be used. All right. Anything else for the record in docket 25-03045? Ms. Fortuna Gill.
Not for the people.
Mr. Freeman.
Only my thanks to the court.
All right. Mr. Jackson, do you have any questions concerning the judgment of sentence?
No, pretty much understand everything you explained to me today, Judge.
All right.
I appreciate you for giving me the opportunity. I won't squander it.
All right. And you might want to go check with Mr. Neves on probation just to make sure you got the ID number and Zoom so you guys are all on the same page. All right.
What floor is he on?
It's on the 5th floor all the way to the right.
No problem.
All right. Thank you, Mr. Jackson. You're all set.
Your Honor.
Thank you.
Have a good weekend.
Thank
You too.
Are we ready on Gary? Oh, Mr. Lee's here in real life.
Mr. Lee is here in real life. That is Miranda Zavala.
Yes, she is here, and it would make sense to start with her.
All right. All right, so we're on the record in docket 25-03174. That is People of the State of Michigan versus Savannah Miranda Zavala. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Savannah Maria Zavala Miranda.
And ma'am, you're Savannah Miranda Zavala or Zavala Miranda?
It's Zavala Miranda. Thank you.
Okay, Zavala Miranda. I'm gonna write that. Make sure that is Zavala Miranda. That's how we have it. All right. All right, this is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, it's my understanding that we are leaving this set for preliminary examination.
And is that a fair statement, Mr. Lee?
That is, Your Honor. Mrs. Zavala Miranda we had considered asking for a dismissal, but we don't want her to have to go through the whole process over again. We will, however, be asking the court for consideration on bond.
All right. We'll leave this on for December 19th, 2025 at 9:30 concerning this matter. So next Friday at 9:30, this is left on for preliminary examination. And Mr. Lee, you wanted to be heard on bond.
Yes, thank you, Your Honor. Mrs. Zavala Miranda has been incarcerated since October 19th. That's almost 60 days, and she's just now making her first appearance. That is through no fault of her own, as she has been in custody of the Ingham County Sheriff that entire time. We would ask the court to consider reducing her bond from the current 1,010% to a PR bond, a $1,000 PR bond, as she is unable to post bond, but in consideration of her inconvenience and because she is sincere in stating that she will participate and be here in person for court next week.
All right, thank you. Any comment on the reduction of bond motion, Ms. Fortuna Gill?
Your Honor, the people would be concerned with a reduction in bond due to the assaultive nature of this crime. Additionally, Ms. Zavala Miranda does have a third-degree fleeing and eluding on her criminal record. That brings some concern to the people.
All right, I have that she failed to appear as of October 31st.
That was when we had a probable cause conference scheduled. She was already incarcerated on October 19th.
Okay.
They failed to bring her over. Just now kind of discovered where she was at, and that's how we got here today.
Because I have DFTA for PCC, and then I issued immediate bench warrant. And so she must not have been on a list then.
I don't
She would have
think
been on our list,
Yeah,
or I wouldn't have issued a bench warrant. That's my fear here. My fear here is not only that we're dealing with a felonious assault, dangerous crime, but I have a previous fail to appear. And if she was incarcerated, I have her previously on probation to Clinton County.
Yes, she is on probation in Clinton County. She was incarcerated, Your Honor. Vine Link confirms October 19. I don't know why she wasn't on the list.
I don't know.
She was incarcerated at that time.
And it's possible I could have missed it. It's been so long.
I don't know whose fault it was. I'm not pointing blame at anybody specifically, but she's been incarcerated for almost 60 days. This is her first appearance.
All right. So for the felonious assault, the previous failed to appear. It does appear that she was incarcerated. It is $100. It's $1,000, 10%. I'm going to deny bond at this time, based on the nature of the allegations in the previous probation to Clinton County. We'll deny bond at this time, and we'll set it for prelim. And then this can be revisited at the preliminary examination next week, which is December 19th at 9:30. Anything else for the record in 25-03174, Ms. Fortuna Gill?
Not for the people.
Mr. Lee?
Nothing for the defense.
All right, you're all set, Ms. Miranda Zavala. We'll see you next week at this time.
Thank you.
If we could go on Gary while we have Mr. Lee up here.
All right, Mr. Gary. Is he? I don't have him on.
Yeah, I still don't have him on Zoom.
I still don't have him on Zoom.
Oh, I'm sorry. Yeah, that is accurate, Your Honor. I have been in contact with Mr. Gary. He has actually been leaving me several messages. He is experiencing technical difficulties trying to connect via Zoom. I'm going to ask the court today if they would waive his appearance today, as we're just leaving it on for PE next week.
All right. All right, so we're on the record in a docket 25-03589. That is People of the State of Michigan versus Maurice Gary. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Maurice Gary.
This is the time is set for a preliminary examination, or probable cause conference, I should say. Mr. Lee is requesting that we waive the presence or appearance of Mr. Gary. He's been in contact with Mr. Gary. Ms. Fortuna Gill, your response to the motion to waive Mr. Gary's appearance for the record.
Yes, Your Honor. The people have no objection to waiving Mr. Gary's appearance. I know that he was on, I heard his voice on Zoom earlier today, and I know Mr. Lee has indicated that he's spoken with him, so the people have no objection to that.
All right, so with that understanding, Mr. Lee, you'll be responsible telling Mr. Gary that we're going to be live in person. We'll leave it on for preliminary examination for December 19th at 8:30. So this is left on for December 19th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 25-03589, Ms. Fortuna Gill?
Not for the people.
Mr. Lee?
No, thank you.
All right, thank you, Mr. Lee. We'd be all set on Mr. Gary.
Good. We are ready on James, Mini James. Gotta bring Bentley up. I think Bentley needs to be brought up for the sentencing.
I don't know if somebody's bringing him up or if I'm just waiting here for.
So you
might bring him up, Megan. I just didn't know.
So we can bring up Bentley. And then we'll go on Miss James. We have a pre-sentence on Miss James.
We do, Your Honor. I was able to review it. I didn't get sent one by probation.
I don't have a probation file.
That file right there.
That was my bad, Judge.
The people are in possession of the PSI as well.
All right. All right. Right, so we're on the record in docket 25026666. That is People of the State of Michigan versus Minnie James. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverman from the Office of Public Defender on behalf of Minnie Lee James, who's standing to my right at council table.
And ma'am, you are Minnie James, is that correct? Is that a yes, ma'am?
Yes.
All right, thank you. All right, this is the time set for sentencing in the matter. Ms. Fortuna Gill, I have restitution in this matter based on the red sheet that was given to probation, $2,920.90. Is that the amount of restitution you have?
That is correct, Your Honor.
Mr. Silverthorne, are you contesting restitution?
No, Your Honor.
Okay. All right, so I'll add that to the restitution amount of $2,920.90. Mr. Silverthorne, did you have the opportunity to go through the pre-sentence report with your client?
I had the opportunity to go through it, but as I indicated to the court, I was not sent that copy. I have gone over the highlights of the report. I don't think that there are any changes or additions.
All right. All right, allocution, Mr. Silverthorne.
Yes, we did ask the court to adopt the recommendation. I think it's fair. I would like to thank her sister, who's the victim in this case, for consulting with the prosecutor, indicating that she would agree to 7694A. Although technically her consent isn't needed, she
Right.
needs to be consulted with, but she endorsed it, and so that we're thankful for that. We're hoping that Ms. Lee can avail herself of the services through probation to deal with you. Check. Okay. We're hoping that Ms. James can avail herself of the services that will be available through probation. It can help her underlying problem, which isn't theft so much as it is misuse of alcohol. And because that's the problem that needs to be addressed.
All right, thank you. Ms. Fortuna Gill, anything you'd like to say to the court before the court passes the sentence?
Your Honor, the people would just request the court follow the recommendation.
All right, thank you. Ms. James, is there anything you'd like to say to the court before the court passes the sentence?
Just really, me and my sister, it was just a big accident. We are a family, and we, my mom and all our family, we all talked about it. The situation's done. We're not fighting, and we're not mad at each other.
Okay.
So it was just a big accident.
Yeah, well, it's my understanding it is an accident, but it stems from alcohol. Okay. And so and that's something you've indicated to the probation department. So use us as a resource. All right. I'm gonna treat this as a learning experience. All right. This is a learning experience. There's no doubt when your sister was talked to, there's no doubt from my opinion that they were on board with seeing that you get help. That helps that's necessary. And that's really the bigger struggle. Okay. That's really the bigger struggle. I'm not concerned about Miss James now because I'm going to have time over you. Okay. I'm really concerned about Minnie James 2 or 3 years from now. You've got to make good decisions, and you've got to decide if you're going to have a productive relationship with alcohol or a destructive relationship with alcohol. This is pretty destructive. All right. I understand sibling rivalry. I think we've taken it up a notch. All right. So let's put it back to where it is, and let's figure out if there's an alcohol problem. I don't think there's any shame in that. Okay. I think that we've done a poor or a disservice in acting like that, and that's not the way it should be. But we've got to figure it out, okay? We could figure out that there is no alcohol problem. That's great news to me. Most people come in front of me because they drop dirty, okay? I'd say over 60, 70%, okay? Coming. And if that's not a case here, this is your time to shine, all right? This is your time to shine. Otherwise than that, we've got to decide, all right, is there an underlying problem? And then we got to look at that. And we have resources for that. So use us for that, all right? But the ultimate decision is going to be made by yourself, Ms. James, okay? Yeah, we can't make it for you, all right? This is for a guilty plea on October 16th, 2025 to assault and battery. It is the ruling of the court that the defendant spend 93 days in jails beginning today. Credit is given for 2 days previously served, and I'll suspend the remaining 91 days upon successful completion of probation. So no upfront jail, okay? I'm going to set fines at $200, costs at $200, crime victims' rights fee of $75, state fee of $50, and then there's a restitution in order here. So I'm going to give you, you're going to be placed on probation for 6 months at $30 a month, which for a total of $180. I'll give you, that can all be paid at the end of your probation, all right? So $400 plus 125 plus 180 plus the restitution of $2,920.90 is $3,625 and $25.90, and the majority of that's restitution. All right, ma'am. And that the restitution in this matter is to be made to a Sharina James. The request for 769-4A is granted. And that's really the carrot at the end of the rainbow. That means this is abstracted in a whole different way, okay? So we're kind of all pulling for you here, okay? No contact with the victim. I'm with Sharina James. No assault or threatening behavior. Not to purchase or possess a firearms, ammunition, or weapon of any kind. Not use, possess of alcohol, marijuana, or controlled substance without a valid prescription. Submit to random PBTs and or urinalysis as directed, and no bars or nightclubs is probably a good idea. You are to attend and complete with verification pay fees for the anger management program. And that is the anger management program and complete substance abuse. So I'll rate under other, complete substance abuse. Abuse assessment. And follow any recommendations. If test positive for a prohibited substance, that's it. If you test positive, then we're gonna kind of try to figure out if there's a problem. All right, ma'am? Okay. All right, and obtain and maintain employment if you haven't already. Anything concerning the judgment of sentence It's essentially essentially the same. There is the anger management group and the complete the assessment and test, and you can follow the direction of your probation agent, will be Joseph Sumter. All right, ma'am. Anything else for the anything concerning the judgment of sentence, Mr. Silverthorne?
Simply, as I indicated, Kurt, previously, I did not get a copy of the PSI.
Did you want?
I don't want the full PSI, just the 3 operative pages.
All right.
They contain the recommendation. I don't need the underlying. If
I think it's only 3 pages.
But sometimes they attach the other things, but that's all I need.
All right, so we'll do 3 cents, and we can get you a copy of the judgment of sentence. All right, too. Anything else, Ms. Fortuna Gill, on the judgment of sentence?
Not for the people.
Ms. James, do you have any questions of me concerning the judgment of sentence? It wouldn't be a bad idea to go downstairs to see Mr. Sumter to make sure you're just on the same page with him. He is the person who'd violate you, and then we'll go from there. But it's a good idea to have him just to be working with him.
Thank you.
All right. All right, let's get you a copy. We'll get you a copy of the judgment of sentence. We'll get you a copy of the pre-sentence and the judgment of sentence for your record. You're all set, Ms. James. Thank you for your appearance today.
Thank you, Your Honor.
I'll take the copy and so I can.
We have Mr. Bentley.
Mr. Bentley.
Yes, Your Honor.
All right. Here's the regular file on, this is probably what the JOS belongs in. It's always the one it's always the different one. So that is the regular file.
Yeah, they just get them all.
Yeah.
We're gonna have a seat, or are you okay, Kate?
I'm okay.
All right, so we're on the record in docket 24-00794. That is People of the State of Michigan versus Jeffrey Bentley. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Bentley, who is standing to my right, who's been brought over from the Ingham County Jail. Mr. Bentley, if you could please state your first and last name for the record.
Jeffrey Bentley.
Thank you. This is the time set for a sentencing in the matter. Ms. Fortuna Gill, do we have any further restitution on this matter?
No, Your Honor.
Mr. Harris, did you have the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor. At this point, we would not have any additions, deletions, or corrections.
Allocution, Mr. Harris.
Yes, Your Honor. I did speak with Mr. Bentley about the recommendation here. He does agree with the recommendation. He is aware that he has the Kent County matter currently outstanding. He does have a PR bond, so if he can get released on this, that would allow him to get released from jail. He did indicate to me that he is currently dealing with some medical concerns that may involve him potentially passing away sometime in the relatively near future, and he's trying to get things in order for that. I would simply ask that the court follow the recommendation here of sentencing him to time served. I believe he has 16 days credit over in Kent County, which I'm not sure if it would count here, and then a grand total of
67.
Well, yes, I believe it's 67 days in total, Your Honor. I believe the probation department indicated there was 51 days since he was transferred to from Kent County, and 16 days that he had over in Kent County. I'm not sure if those 16 days would count towards the probation year. I would ask that the court simply sentence him to time served on this matter, and so that he may be released and get his affairs in order, as well as trying to resolve the Kent County case. Given his extremely limited resources and the fact that he currently is on Social Security disability payments and unable to work, I would ask if the court would consider minimizing or otherwise waiving what fines and costs the court can hear, Your Honor. Thank you.
Thank you. Ms. Fortuna Gill, do you have anything on judgment of sentence concerning 24-00794?
No, Your Honor, the people would just request that the court follow the recommendation.
Right, thank you. Mr. Bentley, is there anything you'd like to say to the court before the court passes sentence?
No, the judge is asking if there's anything you would like to say regarding sentencing. You can make a statement, but you don't have to.
No, Your Honor, other than I'm going through congestive heart failure. Like right now, I can't breathe. I need to go to the hospital. Have an IV put in me, get LASIK shots to get the fluid out of my lungs so I can breathe. And not doing well. You know, I apologize to the courts for even having to be here. Thank you.
Thank you. Well, Mr. Bentley, you're not a kid and I'm not going to treat you like a kid, okay? You have an extensive criminal history here, an extensive.
Your Honor, Mr. Bentley was indicating he was having some trouble hearing.
Would you like an interpreter or some type of device?
If we can, and we might be able to use the assisted hearing device, that might be helpful.
All right, so,
I'm not 100% certain it works.
well, let's see if it works. And then if it doesn't work, we'll reschedule the sentencing to a date where, you know.
Maybe you can just tell me what to say.
Yes, he
I'm having a
seems
hard
to
time
be,
seeing also, so.
All right,
he seems to be able to, I've been able to manage by keeping my voice up, Your Honor, but
I'll try that also, but it wouldn't hurt to give him the device to see if it works. And then if it's not working, we know, and we should get it fixed.
yes, Your Honor.
I do know there's one courtroom that was never set up.
Probably this one.
Yeah, is this one or Simmons? I can never remember.
I know Mr. Freeman has used it on occasion.
Okay,
and
then it's here.
and it hasn't worked.
Oh.
Turned up.
Does that work? Can you hear me? Mr. Bentley, does that work?
I can hear a little better. Yeah.
Okay, all right. All right, Mr. Bentley, you're not a kid and I'm not going to treat you like a kid, all right? This is for the controlled substance use for what's been found guilty on March 28, 2024.
Yeah, for use.
Correct, correct. And that's what this sentence is for.
I quit using in August of this year. I quit drinking, quit smoking cigarettes.
Yeah, that's a long time to wait for all that thing, for all that. Okay, but
I still can't breathe.
the so it is the order of the court based on your criminal history that you spend, and I'm going to give you credit, so I'll give you credit for the 17 days. So that's
it was
49 plus 17. Is that correct?
And 51 plus 16, Your Honor, for a total of 67.
67 days. Okay. So it is your credits given for 67 days. I'm going to have you spend 180 days in the county jail. Credits for 67 days previously served. That's beginning today. So you'll do half your sentence as a part of this. And then you're getting credit for your 67 days. So it's 4 more months. I'm going to waive any fines and costs. I'm going to waive the crime victims' rights fee. I'm going to waive the state fee. So the total amount is 0 for this controlled substance charge but you're gonna get 180 days. So what's 180 days minus 67?
I believe, Your Honor, that should be 113.
Okay, 113 days still to be served on this sentence.
And just to clarify, Your Honor, the court is not going to be following the recommendation.
I will not be following the recommendation based on the fail to appear, previous fail to appears, and the lengthy criminal history by this defendant.
I've been in and out of the hospital.
You're going to continue to be in and out of the hospital.
And the Ingham County Jail will not take me to the hospital.
Well, that's between you and the Ingham County Jail. So this is
Well, I've already
for
told my kids what to do if I die in that jail, so.
perfect 12/20/25, and this judgment of sentence is signed. It'll be 180 days minus the 67 days previously served. Anything else for the record in docket 24-00794, Ms. Fortuna Gill?
Not for the people.
Mr. Harris.
Just to clarify, for record's sake, Your Honor, I did want to make note that I believe this recommendation was prepared after the fails to appear in the long period of warrant status with this in mind. I
Correct.
just wanted that noted for the record.
All right, thank you. You're all set, Mr. Bentley. Thank you for your appearance today.
So how many days I got left to?
I believe it'll be 113. 113 should be out by the start of April.
All right. All right, Mr. Gabriels, you're here for from the Attorney General's?
Yes, Your Honor.
All right, let's go ahead and call that case. Mr. Kuntz, you're here on behalf of, did you want those cases called together? That's the Fisher case, and then Mark Fisher. Well, let's call those separately, just so we have the record to indicate. So we're on the record in 25-03-569. That is People of the State of Michigan versus LPG Incorporated, Fisher LPG Incorporated. Appearances for the record, Mr. Gabriels, and you might have to correct my pronunciation of the name.
Very close, Your Honor. Gabriels.
Gabriels.
Good morning. Mark Gabriels on behalf of the people from the Attorney General's office.
All right. And then Ms. Johnson, you're also here as an Attorney General?
I am Denise Johnson, Assistant Attorney General, and I am here on behalf of the Michigan Department of Treasury.
All right, thank you. And then Dustin Kuntz, your appearance for the record.
Yes, good morning, Your Honor. Dustin Kuntz for Fisher LPG.
All right. And do they have a representative, or are you just representing that entity today?
Well, I represent the entity and Mark Fisher, who's the business owner and the other defendant.
All right. And so with that understanding, we have set this for probable cause conference on today's date. That is December 12th, 9:30. Mr. Gabriel Lease, how are we proceeding?
Two things today, Your Honor. First is my colleague, Ms. Johnson, is here on behalf of the Department of Treasury to seek a disclosure order in both this case and the case against Mr. Fisher personally. There are significant tax records at issue. The Revenue Act requires a disclosure order so that we can provide those to Mr. Kuntz as discovery. So my colleague's here to, she filed the motion and is available to answer any questions the court may have about that. Secondly, after discussions with Mr. Kuntz, I believe Both Fisher LPG and Mr. Fisher will be waiving their 21-day requirement for the preliminary exam so that they are able to receive and review discovery before making a determination about the prelim.
All right. And Ms. Johnson, you provided the motion and order concerning this matter. And Mr. Kuntz, do you have any objection to receiving discovery? I have to sign the order. Is that a fair statement, Ms. Johnson?
Yes.
Mr. Kuntz, any objection to me signing the order?
No, Your Honor, we'd stipulate.
All right. So I'll sign the order. And then Mr. Kuntz, your client as an entity is willing to waive the right to a preliminary examination within 21 days. Is that a fair statement? And I can walk you through that. Do you want me to address any representative of Fisher LPG Incorporated concerning that, or would it suffice to address it yourself, Mr. Kuntz?
Your Honor, I think we could do it either way. The court could inquire of my client, Mr. Fisher,
Okay.
and he can answer for both him. I know you haven't called his individual case yet, but he can answer for both himself and for the company.
So is Mark Fisher also on behalf of the company in representation on behalf of the company? This happens. This has happened before. Would it be suffice to address Mr. Fisher on behalf of Fisher LPG?
Yes.
All right. And sir, you are Mark Fisher, is that correct?
Yes.
All right. And you're here representing Fisher LPG Incorporated, is that correct?
Yes.
On behalf of, so Fisher LPG Incorporated has a right to a preliminary examination within 21 days of date of arraignment. It's my understanding it would be your wish to waive that right to preliminary examination, have this case adjourned so that I just signed the order. Mr. Kuntz can have discovery in this matter, have all the reports, and zealously represent Fisher LPG in their defense. Is it your wish today to waive your right to a preliminary examination within the 21-day period? You wouldn't be waiving your right to a preliminary examination in general, just within that 21-day period, so Mr. Kuntz can get the information, the discovery he needs to pose a valid defense. Is it your wish to waive your right to a preliminary examination within that 21-day period?
Yes.
And Ms. Johnson and Mr. Gabrielis, and I'm butchering that name, do you also waive your right to a preliminary examination within 21 days?
Yes, Your Honor.
My role in this is just to obtain the tax order, so
All right.
this will be my
All right.
appearance.
All right, so I'm gonna have Fisher LPG Incorporated waive their right to the 21-day rule. And then it's best for the parties, when should we reschedule this, and should we reschedule this for preliminary examination or for probable cause conference? Mr. Kuntz, about how much time do you need? There's probably, you're in on two cases. They probably have the same information, but you know if this is a voluminous documentation or whether it's short documentation. So I'm thinking sometime after the holidays.
I would agree, Your Honor, and I would ask that we set it for PCC. I think there's a good chance that this will be a waiver of exam in the end. So if we set it for PCC, we can. And
Mr. Gabrielis, is that a fair and accurate statement at sometime after the holidays?
Yes, the people are comfortable with a PCC after the holidays.
All right, so we'll set it for PCC. And we can set it for PCC during January, and let's set the prelim sometime after that.
Yes, unfortunately, they haven't allowed me into JIS.
Oh, that's right. And we don't.
And I've had a ticket in all morning.
All right, so let's, so we'll set it, and we have a scheduling issue because we can't get in JIS, and my court officer is bringing somebody up, I think, after taking somebody down. So why don't we do this? We will set it for, we'll set PCC for February.
Oh, there she
Oh,
Oh, they might be-
I think we have it. I think we have her here.
Here.
You're the only person on JIS evidently. So,
Well, I already knew that.
okay, so you can schedule, we'll need a PCC for the last week of January and then the prelim, we can set it for February.
So we need 2 dates then.
Yeah, I think 2 dates. They waived the entity, the Fisher LPG has waived the right to a 21-day rule. So we need 2 dates, one for PCC and one for prelim. So that
The last week of January.
I would think that I may or may not be back depending, but I probably will be. So we can set it for that date. That way that nobody else gets it.
PCC date, correct?
Yeah, PCC date.
We do Thursday, January 29th at 8:30, 9:30, I'm sorry.
At 9:30?
Yeah,
All right.
does that work?
Yeah, well, it should work. It's January 29th at 9:30 for PCC. Does that work for your schedule, Mr. Gabriels or Gabriels?
Yes, it does.
Mr. Kuntz, does that work for your schedule? January 29th at 9:30?
Yes.
All right. So that'll be the PCC date. We'll set up a corresponding preliminary examination for
Sorry,
probably the next week.
yeah, I would have said the next week.
Your Honor, would we be able to do 2 weeks after? I think I have a scheduling issue the week after that.
All right. So that would be the second week of February. Is that correct, Mr. Kuntz?
Yes, and if that,
All right.
of course, if that works for Mr. Gabriel's too.
I have no objection to prelim that week.
So it's the second week of February.
We gotta check the.
You got to check the.
I can only do one at a time.
No, you must do all things at all times. That's the rules.
That's a prelim date, correct?
Yeah, prelim date for the second week of February.
We do 8:30?
Yes.
February 5th.
February 5th. Is that okay, Mr. Kuntz? February 5th? Or are you
Your
looking
Honor,
for?
that's what I was trying to avoid, was that week.
Okay. Yeah, let's go the following week to see if that's available.
Probably the Friday the 13th then?
Okay, so how about Friday, February 13th? Does that day work, Mr. Kuntz?
That works for me.
All right. All right, we'll set it for February 13th at what time?
8:30.
8:30. All right, so on 2503-569, I've signed the order which will allow discovery. We've set the Fisher LPG Incorporated. The 21-day rule was waived, and we've set for probable cause conference for January 29th at 9:30 and February 13th. The preliminary examination is set for February 13th at 8:30. Anything else for the record on that file, 2503-569, Mr. Gabriels?
No, Your Honor.
Mr. Kuntz?
No, Your Honor.
All right, so we're all set on that file, and then I'll call the personal, I'll call 2503-570. I'll need those same, give me that file, because I'll just take it from those dates, the same ones. So we're on the record in 2503-03570. That's people of the state of Michigan versus Mark Fisher. Appearances for the record, Mr. Gabriels.
Good morning, Your Honor. Mark Gabriels, Assistant Attorney General on behalf of the people.
And then Ms. Johnson is here as for the Department of Treasury. Is that correct, ma'am?
Yes, Denise Johnson for the Michigan Department of Treasury.
And then Mr. Kuntz, once again, your appearance for the record.
And Dustin Kuntz for Mark Fisher.
All right. And sir, we have you as Mark Fisher. You're labeled as Douglas Fisher, but you are Mark Fisher. Is that correct?
Yes.
All right. Thank you. And you can hear me all right, Mr. Fisher?
Yes.
All right. Thank you. This is a time set for a probable cause conference. Mr. Gabriels, I assume we're going in the same direction. So there's going to be a waiver of the 21-day rule and then an order to satisfy the discovery request. Is that a fair statement, Mr. Gabriels?
Yes, it is.
All right. And Ms. Johnson, you have filed a motion in order for discovery to provide discovery. And that's the order. There's a request to sign it. Let me find the order on that one. Here it is. All right. Ms. Johnson, you've prepared the motion in order for discovery for purposes of explaining that I have to sign this for the discovery request. Is that a fair statement, Ms. Johnson?
Yes, relating to taxpayer information. That's correct.
All right. Thank you. And Mr. Kuntz, do you have any objection to me signing the document?
No, Your Honor.
All right. I will sign the document. All right. And then it's my understanding, Mr. Kuntz, that Mr. Fisher is going to waive his right to a prelim within 21 days. Is that a fair statement?
That's right, Your Honor.
May I inquire of Mr. Fisher of his waiver of the 21-day rule?
Yes, please.
All right. Mr. Fisher, you understand you have a right to preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dustin Kuntz. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish to waive your right to a prelim within the 21 days. Have this for discovery purposes, Mr. Kuntz. I just signed the order for him to have discovery so he can zealously represent you in your defense. It's my understanding it is your wish to waive your right to a preliminary examination. Have this case adjourned outside of the 21-day period, so Mr. Kuntz will have all the information necessary to pose a defense. Is it your wish today to waive your right to a prelim only within that 21-day period?
Yes.
And Mr. Gabriels, do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
Okay, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And we will use the same dates that we used for the Fisher LPG Incorporated entity. So we'll set for PCC for January 29th at 9:30. And then we'll set for prelim for February 13th at 8:30. Any objection to any one of those dates, Mr. Gabriels?
No, Your Honor.
Mr. Kuntz, those are the same dates we use for the Fisher LPG entity. Do those dates work for you?
Yes, Your Honor.
All right. All right. We have waived the 21-day rule concerning 25-03570. I've signed the order for discovery, and we've set it for probable cause on January 29th at 9:30 and preliminary examination for February 13th at 8:30. Anything else for the record on that file, Mr. Gabriels?
Just two things, Your Honor. First, for the PCC, is Zoom acceptable, or would the court prefer us in person?
You can Zoom is acceptable for the PCC.
And second, would it be possible to have the two disclosure orders emailed to either Ms. Johnson or to me? It's nice to have those in hand before we start sending out tax information.
I think that's a fair request. this would have to make its way through the civil department because I think they want the signed order, I would think. The criminal department,
Yes.
yeah. This will have to make its way to the criminal department because I signed it on the bench, and then they'd be responsible, or we would be responsible, I'm not sure, for mailing it to the Attorney General, mailing that order to the Attorney General, or providing the order through scan.
Yes.
A scanned copy would be sufficient to at least, then we can send discovery out to Mr. Coons if that would be possible.
Perfect. All right. So we'll scan the order in both files, and then you can provide discovery. Anything else for the record in 2503-570 or 2503-569, Mr. Gabriels?
Not for the people. Thank you.
Mr. Coons, do you have any questions of me today?
No, thank you, Your Honor.
We should be all set on those files. Thank you for your appearance. We'll make sure you have a copy of the order so you can provide discovery.
Thank you very much.
Thank you, Your Honor.
Thank you. Thank you, Ms. Johnson.
Thank you.
All right. Mr. Richard Allen. Mr. Goodrich, that's your case?
Yes, Your Honor.
All right. All right, so we're on the record in docket 2502684. That is People of the State of Michigan versus Richard Allen. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Allen, who's standing to my right.
And sir, you are Richard Allen, is that correct?
Yes, I am.
All right, thank you. This is the time set for a sentencing in the matter. Ms. Fortuna Gill, is there any further restitution in this matter? I don't have a pink sheet on the file. Is there any further restitution?
No, Your Honor.
All right. Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, we went through that yesterday.
Okay. Any additions, deletions, or corrections?
No, Your Honor.
Allocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, speak with Mr. Allen. I think it's very clear that he has a very significant alcohol issue. He's also had some other issues with other drugs. I think the one thing the court needs some background information that's, I think, occurred since this report was originally, since the interview. He was arrested on November 21st in a home invasion type of case involving his mother in East Lansing. That case just got bound over yesterday. I believe he waived his preliminary exam at that time. I know on that file, the plan is to pursue some type of long-term treatment on that case. So it's like I said, a little awkward on this case because we don't know exactly what's going to happen on that case. I would ask the court to do, I guess, one of two things. One, either sentence him to a term of probation with requirements of doing some type of alcohol treatment, or two, just doing some type of time served or 30-day sentence, because he is going to be incarcerated, I believe, for his next hearing will probably be at least a month out on the other file. And the bond is set on that one, $50,000. So he's very unlikely to get out on that other file.
Do we want to just adjourn this sentencing to see what's going to happen on the other file?
Your Honor, that's probably going to be a long time.
Yeah, that's my fear, but if part of probation is going to be circuit court probation, then I don't know if duplicating that probation while he's incarcerated on another file is going to be worthy. I could sentence him to a straight jail sentence, but he's facing at what, 180 day and a 1 year. Yeah. So it's really up to him. If I'm willing to adjourn it out to see, or to get close to get a date. But I don't want to I don't want to remake the wheel here if probation is going to be a part of circuit court.
So I guess we could set it out.
It's entirely up to you. I just don't know. I kind of don't know what to do with the pending case in circuit court.
Well, Your Honor, I guess one thing the court could consider is if the court were to do like a 30-day or 60-day sentence, that would be punishment for these matters and not interfere down the road with some type of like residential treatment or something along those lines. Otherwise, like I said, I mean, we could have it set out 90 days, 120 days. I mean, it's going to be a lengthy adjournment.
Ms. Fortunigill from the people. I mean, that's the problem. We have a pending circuit court case. Who's that pending in front of?
It just got bound over yesterday, so it
Okay,
won't
so
be
you don't
assigned yet.
have a judge on that.
Your Honor.
I can adjourn it out for 30 to 60 days, or we can go with a straight sentence. I'd say right now that Mr. Allen is probably, with his criminal history, is looking at significant time. I don't know what his credit on this case is.
You know, I'm not sure he has any credit on this case, so that's, I guess we would rather have the court set it out certainly than do something
Right.
like a 365 days, because then that'll prevent him from getting into some type of treatment down the road.
Absolutely. But there's a significant history, but if circuit court's willing to place him, in inpatient, but I don't know. I guess I don't know. So I'm telling you, I guess I don't know. Ms. Fortunigill and then Mr. Goodrich.
Yes, Your Honor. I don't know either. It's truly whatever defense counsel prefers. I have no objection either way. I see the predicament. I have no objection to setting this out. But it's truly up to Mr. Goodrich.
So Mr. Goodrich, I'm going to leave it in your capable hands. Would you like an adjournment or would you like a sentence? If you want to discuss the case in chambers, we can discuss Mr. Allen and then he would have some indication of how the court's looking at this.
Your Honor, that may be a best decision.
All right. So let's discuss this in chambers. At least Mr. Allen will know what he's looking at and he can make an informed decision.
All rise.
Okay, I see. Give me a seat. Shelley, can I have you show me how to remove big set for next week?
Sure.
For these PCCs and whatnot. You finish scheduling.
I mean,
this.
heck, I can probably. Is it just an A?
I gotta finish scheduling this really quick.
A.
And then-
Oh.
Yeah. So isn't it you just put
See, like,
A in?
I need to get rid of this date.
When you print the notice, well, from there,
I can.
you can
Well,
just
yeah,
go
you-
out of it.
Yeah.
Well, I'm gonna,
Just-
I mean, like, remove it from the
Yeah,
calendar.
Yeah, so print that. Now go to that date, what was it, 12/19?
Gotta remove all of them.
Yeah.
Oh, wait, maybe they, oh, right here.
There you are. So go, if you look, remember up here?
Yeah.
Oh, sure. So you do an A. You're good to go.
Yeah, 'cause D would delete the time slot.
Mhm.
You don't want to do that.
There you are. Is that all you needed, honey?
Yeah. Do I have to put like what date it was adjourned to or anything?
No,
Or does
no,
it just
no,
take it?
no.
Just put A and double click it and it'll probably be done.
And then they want to change this to a PCC date. How do I do that on JIS?
Who was that?
The Anthony Mitchell case.
Oh. Go to that date. See, sometimes leave it on like that, but go to the notes and just put treat as PCC. You don't have to change it to a
What do
PCC.
you, on the notes where?
Like here, go SCH. Because Haley already knows you're doing a PCC, so she's not gonna subpoena. So you can go, nope, not the calendar, go in your regular. Yeah,
Yeah.
and then the case number.
03646.
Now you do MS. And then just go all the way down here. And then I usually put leave on for PE / treat as PCC. There you go.
Yeah, look at Shelley being the mentor.
And then just put a note on here so you remember yourself or somehow to remind yourself that that's what you're doing.
Okay.
Thank you, Shelley.
Reminds me of back in the day. I know you are, Shelley. I believe it. I think there's only a few things, like one or two things left.
This one and Aaron's.
In the end, like, I'll.
Not that
Set my home to ball.
extension.
No, it's fine. It's from my teeth.
I'm aware of that. So your language was the moment on base comes to criminals, the moment
out.
of retiring.
I'm out.
You're throwing your hands up and are like, nope.
There is no way, no way.
So I don't think you get that. Coming back now.
Yes.
Before you get it resolved.
Okay, all right, let's give it a chance.
All rise.
All right. Did you say all rise?
I did.
Oh.
I cut you off, so I said sorry.
All right, so we're back on the record. Ms. Schroeder, is your client going to join us by?
By Zoom, yes, he did just so he actually is probably on Zoom right now. We're trying to get in.
All right. All right, so we're back on the record in docket 25-02684. Mr. Goodrich, you have had the opportunity to talk to Mr. Allen, is that correct?
That is correct, Your Honor.
All right, and how are we proceeding today? You've had the opportunity to go over the pre-sentence report. We've discussed some of the options that are available to us. I had a discussion in chambers with Ms. Fortuna Gill and Mr. Goodrich. Mr. Goodrich has talked to his client. So allocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, Mr. Allen certainly have plans to address his alcohol issues in that circuit court file. We would ask the court to sentence him to a jail sentence today on this sentence and these charges. He would begin that, and he'll use that time to have a break from alcohol and hopefully get the treatment he needs from the circuit court after he completes the sentence. Your Honor.
All right. Any comment from the judgment of sentence or allocution once it's been made by Mr. Goodrich and Ms. Fortuna Gill?
No, Your Honor.
Okay, so I'm not following the probation request. Mr. Allen, is there anything you'd like to say to the court before the court passes sentence?
Yes, absolutely. I'm grateful that I did have the opportunity to resolve all of this, and I apologize for the fact that I was a pain in the butt to get in trouble again and have to be bound over to circuit court, which is to be expected over the long haul of my incarcerations and my stupidity with drinking and drugging. And I'm grateful for the fact that you're giving me this opportunity to straighten my life out. I'm not getting any younger. I'm pushing 52 years old, and it's I'm a hot mess, you know, and I got to get this stuff taken care of. And I was my main question is about my driver's license. What is the stipulations on that part, far as me getting that back? Because I had a 625G something on it. It's called because alcohol was involved. And for the Secretary of State, I'm wanting. This is why I'm here, is because I want to do the right thing, take care of it, so I get my driver's license back. This is.
And this will be abstracted. This operating with a high BAC will be abstracted to the Secretary of State. I don't have an answer for that.
So when you say abstracted, I'm not understanding.
I mean, this conviction will be reported to them, and then they're most likely going to act on this conviction of high BAC, which is what you pled to.
And I would say you should expect that your license will be suspended for a year, and then at that point you'll have to take steps to try to get it back.
So there's no way of getting like what they call it.
That's up to the Secretary of State, not Judge Flores.
Yeah, that's a different bureaucracy you're dealing with. Okay, We have our own bureaucracy that, that we're trying to take care of.
Yeah, I'm just trying to get it clarified because I'm not understanding. They told me that I had to come here to take care of it. And then
That's true.
basically to get like a restricted driver's license. Am I capable of that? Or do I have to go back to Secretary of State?
You're, after you're sensed on this, you're gonna have to go back to the Secretary of State.
Also, so basically when I'm out and about, when I'm able to, I have to go back and say, hey, look, I went to court on this, I did my time. And then they would say, well, yay or nay, or what I need to do.
Correct.
And
Correct.
what
And then that might put you in a position to go back to circuit court to see if some type of license restoration, but I'll leave that in your capable hands because I'm guessing now.
And just to understand, the Secretary of State's not gonna give you any state of license until you get until you get alcohol treatment and stuff and all those
Oh,
things.
okay, okay,
Just so you understand.
Okay, so, yeah,
Reality.
so basically okay, so I did do right by everything as far as me getting treatment, because then that's gonna be,
Absolutely.
okay, that's.
Yeah, that is the road to
Sorry,
getting
sorry,
your
I
license
was
back,
just,
Yeah,
just trying to get it all.
Yeah, you're on the road to getting, but that's a different that Secretary of State, they're gonna set their own rules.
That's a future type
Yes.
situation. All right. thank you.
Absolutely.
I appreciate it.
No worries. All right, for the plea on October 16th, 2025 to the attempt R&O and the operating with a high blood alcohol content, the defendant is to spend 180 days in jail. And that begins today. Credits given for any days previously served. I don't see any, but I'm willing to amend that. But I have 0 days previously served. I'm gonna waive any fines and costs. I'm gonna waive any crime victims' rights fee and waive a state minimum cost fee. There's no restitution. I'm not placing you on probation. And so that'll be a zero amount. Then you'll do, so, I mean, you're gonna be on probation circuit court for depending on what happens on the file.
Right.
But you serve your 180 days on this file and it should be completely done, okay?
Okay.
All right. Anything else for the record on docket 2502-684, Ms. Fortuna Gill?
Not for the people.
Mr. Goodrich?
No, Your Honor, thank you.
All right, you should be all set, Mr. Allen.
Okay, thank you, sir.
You should be all set. Thank you for your appearance today.
Yeah, this is the county concurrent, but you weren't out on this case.
Right. I'm just trying to treat it.
Thanks, Judge.
Thank you, Mr. Goodrich. DOS always goes in the, never goes in the file I think it should go.
You know what? You just put it in one file, you keep it like that, and it's in both.
Miss Schroeder, did you want to go on your file?
Yes, has he joined us?
He has not.
What?
He has not joined us.
Okay.
And that was set for PCC.
It was, and my office has had contact with him, and I can make a record.
All right.
Your Honor.
All right, so we're on the record in 25-03619. That is, oh, we just got somebody.
Excellent. I've been seeing my thing lighting up on here showing, I
All
think
right.
he's been calling my paralegal trying to get assistance with getting on.
All right. All right, sir, on the Motorola Moto G, are you Cornelius Shannon? And you'll have to unmute.
Hello, yes, I am.
All right, thank you. All right. So we're on the record in 25-03619. That is People of the State of Michigan versus Cornelius Shannon. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Shannon. Mr. Shannon joins us by Zoom here today.
And sir, you are Cornelius Shannon, is that correct?
Yes, I am.
And you can hear me all right, Mr. Shannon?
I can hear you. Go ahead. I can hear you.
Okay, perfect. Thank you. This is the time set for a probable cause hearing or probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, it's my understanding we'll be leaving this set for preliminary examination. An offer has been extended and that offer would remain open to the beginning of the preliminary exam.
And is that a fair statement, Ms. Schroeder?
Yes, Your Honor, and I will be in contact with Mr. Shannon later today to discuss that offer. I just received it this morning, and we will make sure that we are ready regardless for next week. Thank you.
All right, thank you. Mr. Shannon, we've set the preliminary examination for December 19th at 9 a.m. That's December 19th at 9 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. All right, Mr. Shannon, next Friday at 9 a.m.
December 19th, 9 a.m.
Perfect.
Yep.
Anything else for the record in 2503619, Ms. Fortuna Gill?
Not for the people,
Ms. Schroeder.
Not for the defense. Thank you.
All right, we'll see you next week at this time at 9 a.m. Okay, sir?
Yes, yes, sir.
All right, you're all set. Thank you for your appearance today, Mr. Shannon.
Okay,
And I will be in touch later today, sir, okay?
Okay,
Thank you.
thank you. Bye.
We have Ms. Fortuna Gill, you're gonna have to help me.
Sure.
Did we do Mitchell already? Anthony Mitchell. Oh, that was Miss,
Yes.
that was the, all right. I don't have anybody else then.
okay, perfect.
You don't have any more files and I don't have any more
Good,
files.
okay.
I think we're
yes.
good.
Then we are.
Ms. Schroeder, thank you for being so patient,
Well,
but it kind of worked out.
It worked out very well, because we've been trying to get a hold of Mr. Shannon this morning, and then
And it did, and he was able to show
he
up.
was able to get on. He was at, he ended up,
Yeah.
oh, crap, I slept in, and I didn't think about it, and I went to work, and then I realized, crap.
Well, I'm glad getting stuff going last.
We have weddings at 1:30, Megan, is that correct?
That is correct,
All
and
right.
2, 1:30 and 2.
1:30 and 2. Thank you, Shelley, for helping us out today.
I'll see you Monday.
Think about that,
Okay.
yes, I just gotta go to work.
We'll see you, Mr. Harris. Thank you.
Thank you.
Have a nice
Phone
weekend.
eventually realized, oh, we've been trying to get hold of you.
Yes, and we are not having a trial on Tuesday. I already told Megan, but well, I already let MDOC.
Funny, because Megan doesn't care, obviously.
Regardless, so.
You have got too many.
I'm gonna have a great weekend.
You too. Thank
See you
you.
Tuesday.
Thank you.
Oh, you're probably.
Obviously, he's Jonas Brothers, that's fine, so I'm gonna have a good
Fine.
weekend. They've had a chokehold on me since I was 8 years old.
Fair.